Now I am going to dictate a legal passage based on a judgment of Supreme Court of India at the rate of 120 words per minute. Let's start. This appeal arises from the judgment passed by the High Court of Madhya Pradesh, wherein the conviction of the appellant under Section 304B of the Indian Penal Code was upheld, sentencing him to rigorous imprisonment for 10 years for the alleged dowry death of his wife Sangeeta Singh Pera. The facts of the case, briefly stated, are as follows. The appellant was married to the deceased on 12 June 2019 and they resided in Bhopal. The prosecution alleged that the deceased was subjected to persistent harassment for dowry demands and that her unnatural death occurred within 7 years of marriage, thereby attracting the statutory presumption under Section 304B para. On 18th March 2022, the deceased was found dead in her matrimonial home under suspicious circumstances. The inquest report indicated signs of poisoning and the postmortem confirmed the same. The FIR was registered by the deceased brother, who alleged repeated demands for cash and a four-wheeler from the appellant pair. During trial, the prosecution examined 12 witnesses, including the parents and siblings of the deceased, all of whom testified regarding the harassment and demands. The defense, on the other hand, relied on one witness, the neighbor, who stated that no loud arguments or suspicious activity was noticed prior to the incident pair. The trial court convicted the appellant, relying primarily on the testimony of the deceased mother and the postmortem report. It held that the burden to rebut the presumption under Section 304B lay on the appellant, which he failed to discharge pair. On appeal, the High Court affirmed the conviction, reiterating that the death occurred in unnatural circumstances within 7 years of marriage and was preceded by cruelty linked to dowry demands. Before us, learned counsel for the appellant argued that the High Court erred in appreciating the evidence and that the prosecution failed to establish a proximate connection between dowry harassment and the death. It was submitted that minor domestic disagreements were exaggerated and there was no direct evidence of poisoning. On behalf of the respondent state, it was connected that the statutory presumption under Section 304B was rightly invoked and that the deceased family had given consistent accounts of harassment supported by documentary evidence and medical reports. We have carefully examined the record and considered the rival submissions. The essential ingredients of Section 304 IPC are within bracket A, death of a woman caused by burns, bodily injury or occurring otherwise than under normal circumstances, within bracket B, within 7 years of marriage, and within bracket C, shown before her death she was subjected to cruelty or harassment in connection with dowry. In the present case, the death occurred within 3 years of marriage. The postmortem clearly confirms unnatural death due to poisoning. The statements of the deceased mother and brother, though interested witnesses, find corroboration in the complaint records and other evidence. The appellant has failed to furnish any plausible alternative explanation for the deceased death or disprove the allegation of harassment. The defense argument that the deceased may have committed suicide due to personal issues remains speculative and unsupported by evidence. Further, the appellant did not examine any family member or produce call records, letters or any form of communication to rebut the prosecution case. It is well settled that in cases involving dowry death, circumstantial evidence plays a pivotal role. The standard is one of preponderance of probabilities rather than proof beyond reasonable doubt, especially where direct evidence is scarce due to the nature of domestic occurrences. Para. The trial court has rightly appreciated the evidence in its totality and reached a conclusion that the prosecution had discharged its burden. The High Court's affirmance of that view is also in consonance with the law laid down in Hiralal versus State of Rajasthan within bracket 2009 and State of Punjab versus Iqbal Singh within bracket 2021. Stop. Thank you.